head is beautiful. You're gonna love the back of your head. We all just stare at each other.
Why don't you sit on the other side of Tana? I'm both Cal.
Great, thank you.
Hi, how you doing?
Brian,
Fine. Hi.
I'm sure. Oh, I don't know. Usually it's just one of them. They're usually not both here, right?
Email them
Yannetti, California attorneys, are they going to be on Zoom?
They'll be on Zoom, but they won't be arguing.
Okay.
Oh, he was here earlier.
He's Greg Henning.
Can you make one to Zoom?
Do you want to be on Zoom?
Not really.
That's fine.
Hat off, sir. Sir, take your hat off.
The color coded hat. Have you had that in here? Thank you.
Not today, just filing.
All right. Thanks, Greg.
Thank you.
True, you used to work in Suffolk with Margaret?
You are unmuted.
Just TV? TV only.
Ask me for anything on that.
No, I understand, but I'm just. That is the.
I just have a brief comment as to the first meeting. Yes. So I think. No objection. Okay. And then the other one is that I don't have anything written, but it's just based, I guess.
Let me see if they confirmed it. I guess she's signed to Dedham District now, Martha. So you could always just call her if not. Right.
baseball will catch up on.
The motion to the future? I don't have that. Thank you. Just remind the folks about the cell phone use, okay? About the ring of those cell phones go out, okay? Taking those cell phones go off first, and you'll off first. What should you do?
Roll.
We're going on the record.
Officer John, why don't you come upstairs?
All rise for the court, please. Now open the meeting, seated.
Good afternoon, Your Honor. We are on the record on Commonwealth versus Karen Reed on docket 22 CR 117. Beginning with the ADA, can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your
Good
Honor.
afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DeStefano. In his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from State Police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay, all right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton Police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that, Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton Police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the recusal, the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to
So
provide them as well.
they're two separately filed motions, right? And
Yes.
One of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and one, the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except
But
for
that's three different people, or one different person on this.
one different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right,
Right.
okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred, and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for, from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard under Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron protocol says shall, Doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so out of an abundance of caution,
Okay,
that's-
no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess, you can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
my apologies, Your Honor.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So,
Can I have one moment, Your Honor?
yes.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow, allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here for Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great, thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right, thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Paschuko on behalf of Kevin Albert.
All right, so you need to spell that last name
Sure,
for
it's
us.
P-A-S-C-I-U-C-C-O.
Good afternoon.
Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide, or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third-party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them, and I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed, and it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January
for Brian
29th.
Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th.
4th.
That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits. Contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
that's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third-party counsel if they want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's Attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, with respect to our general arguments, we'll just rest on I'll rest on what I said previously, and we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that for the record.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be a relevant time period?
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right, we're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pretrial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is what
No,
the...
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week?
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is if you're not here and you have to be here
that's
for
why
that.
we did.
So
That's why we did that, so.
Ms. Yannetti will, I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
March 26, 9 a.m., hearing on all pretrial non-evidentiary motions.
All right. Brian? All right, Brian, we have a 3 o'clock list.
I'll come in and let you know what's left on the list.
Okay, thank you.
You are muted.
Oh, the Duarte one, attorney can't, she asked for Zoom, but now she can't do it, so we're in good shape.
Goodbye.
So I think we're going to go, are we free to go?
Hand it up. How are you? Good plan. A perfect plan. Thank you, Tori. We have warrant recall. You have this one yet? Oh, it's Sarah? Mr. Sarah? Martha? Who are you? Billy Keith was here asking if there was an interpreter, and I said, I know Martha will be here.
Of course. I wasn't here earlier because you had a...
Yeah.
So I waited.
Developing right now on Morning News Now, blocked. A controversial Texas immigration law put on hold by an appeals court just hours after the Supreme Court allowed it to take effect. We have team coverage on the legal back and forth that's sparking a debate far beyond the southern border.
Jesse Palmer?
So you do remember, and I know you haven't been watching.
I know, but TV's expensive.
Well, now you can watch me live sports and news free. No contracts or fees.
But Jesse, how?
Tableau. Pay once and watch happily ever after. And you can record too.
That sounds like a dream.
Tableau. Learn more at tableautv.com. It's not fantasy, it's reality.
No tracking needed for 200-plus certifiably nutritious Zero-Point Foods. Join Weight Watchers today.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, honored to be with you for the next 3 hours. Our Court TV cameras are in 2 different courtrooms this afternoon. First, in New Hampshire, defendant Timothy Verrill is standing trial for a second time for the 2017 murders of Christine Sullivan and Jenna Pellegrini. Prosecutors claim that Verrill stabbed the 2 women after becoming paranoid that one of them was an informant with the police. The defense, though, says that Sullivan's boyfriend, who owned the home where the women's bodies were found, is the real killer. We will get you back into that courtroom later this afternoon. But first, we want to head back to Massachusetts, where we are watching a motions hearing for Karen Reed. This is a Boston woman accused of killing her boyfriend and police officer John O'Keefe. But interest in the case has grown after her and her defense team have claimed that the killing was really a cover-up by O'Keefe's fellow officers. Big news. You can see all the people there that have been following this and protesting and claiming her innocence. Let's get you back into court now, right where we left off. Attorneys are making arguments to the judge about why their client's phone records should not be released as part of the discovery.
That he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them, and I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Albert to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCain Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian
Defendant Timothy Verrill is standing trial for a second time for the 20.
No tracking needed for 200 plus certified. No tracking needed for 200 plus certifiably nutritious 0-point foods. Join Weight Watchers today.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, honored to be with you for the next 3 hours. Our Court TV cameras are in 2 different courtrooms this afternoon. First, in New Hampshire, defendant Timothy Verrill is standing trial for a second time for the 2017 murders of Christine Sullivan and Jenna Pellegrini. Prosecutors claim that Verrill stabbed the 2 women after becoming paranoid that one of them was an informant with the police. The defense, though, says that Sullivan's boyfriend, who owned the home where the women's bodies were found, is the real killer. We will get you back into that courtroom later this afternoon. But first, we want to head back to Massachusetts, where we are watching a motions hearing for Karen Reed. This is a Boston woman accused of killing her boyfriend and police officer John O'Keefe. But interest in the case has grown after her and her defense team have claimed that the killing was really a cover-up by O'Keefe's fellow officers. Big news. You can see all the people there that have been following this and protesting and claiming her innocence. Let's get you back into court now, right where we left off. Attorneys are making arguments to the judge.
Twenty-7th, 2017, the defendant, Timothy Verrill, a paranoid drug dealer trying to protect himself, his business, and his boss, brutally murdered Christine Sullivan and Jenna Pellegrini.
This is Court TV Live. We are your front row seat to justice. I'm your host, Julie Grant, and it's great to have you with us this Wednesday. So during this hour, we're going to be bringing you the very best moments in day number 1 of the Small Town Secrets murder trial. This is happening in New Hampshire. Testimony is set to resume in our next hour. The defendant is Timothy Verrill. He's accused in the brutal deaths of 2 women. Here's Court TV anchor Michael Ayala with the back.
The defendant, Timothy Verrill, a paranoid drug dealer trying to protect himself, his business, and his boss, brutally murdered Christine Sullivan and Jenna Pellegrini. Dean and Christine were drug dealers, and the defendant worked for them. At about 6:57 a.m., the defendant quickly walked to the door and locked it. At this point, the only 3 people in that house were the defendant, Christine, and Jenna. The murders were disorganized and hyper. They weren't cold and calculated. They were emotional and they were passionate. The defendant struck Christine multiple times in the head with a blunt instrument. The defendant murdered Jenna while she was in bed. As with Christine, the defendant also struck Jenna in the head. The defendant then stabbed Jenna to death, inflicting 43 stab wounds. Defense is going to come up here, and they're going to tell you that somebody else murdered Christine and Jenna. There is no boogeyman. The evidence in this case will show that the defendant is the only one who cleaned up the scene, the only one who fled from the police, and the only one who killed.
Christine and Jenna fought back against their killers. They fought so hard that their killer's DNA got embedded under their fingernails. That killer's DNA was not Tim's. The state must answer every question that gives you reasonable doubt. And when they don't, you must acquit Tim. The state's inability to answer these questions starts with the investigation. The police carried out a distracted and incomplete investigation. Now, we're not saying that this was a dishonest investigation, but rather that it was fatally flawed. It's important to know that federal agents were investigating Dean's multi-state drug operation prior to the murders. Dean and Josh would discuss the Tim problem. Tim was distancing himself, becoming hard to reach. He was missing delivery appointments. You'll hear from others how Tim was getting sick of this world, but leaving it is
.979 Meterboro Road in Farmington. The defendant struck both women in the head multiple times. He stabbed Christine 8 times in the neck and chest. He stabbed Jenna 43 times in the neck, chest, and back. He murdered Christine in the porch area of the house. Christine tried to defend herself, but she was unsuccessful. The defendant murdered Jenna while she was in bed, likely sleeping or unconscious. And after committing these murders, the defendant took disorganized steps to try to hide what he had done. He wrapped the bodies in various tarps and other coverings, and he discarded them like trash underneath the porch. A large pool of Christine's blood had frozen outside on the porch, so the defendant attempted to melt the ice using Prestone driveway heat ice melter. He also covered the icy blood with a small rug. The defendant also concealed a number of bloody items, as well as some of Jenna's personal belongings, in a black plastic and a clear plastic trash bag in the laundry room of the house. 979 Meterboro Road was the home of Dean Smoronk, the on-again but mostly off-again boyfriend of Christine Sullivan. Christine lived there too. Dean and Christine were drug dealers, and the defendant worked for them. In fact, the defendant would sometimes take over business when Dean and Christine went away, such as when they would go down to Florida. In January of 2017, the defendant had started acting strange. He was using a variety of drugs. He grew distant and paranoid, at times not even seeming to be aware of what was going on around him. Friends were so concerned that they tried to get the defendant to see a doctor. About a week before the murders, things seemed to have improved. A friend of the defendant's named Kathy Bradstreet gave the defendant a ride. During that ride, she noticed he seemed to be doing better. The defendant told Kathy that he had been doing too many drugs and that he had been having crazy thoughts, but that he had stopped doing everything. However, not long after that, if he had even ever truly stopped at all, the defendant began using drugs again. Cocaine, crystal meth, and others. And he once again grew anxious, frantic, and emotional. Let's start by focusing on the end of January 2017. Early in the morning of January 25th, 2 days before the murders, Dean left his home in Farmington to travel to Florida, flying out of the Logan Airport in Boston. Dean had installed a surveillance system inside the house at 979 Meterboro Road. And you'll see video and images of Dean preparing to leave at about 3:50 that morning. Dean is the man circled in blue, and the man circled in orange there is Josh Caldwell, who at the time was a drug associate of Dean, Christine, and the defendants. You'll also see video and images from the Logan Airport, showing Dean going through security at about 5:30 and boarding his plane at about 5:55 that morning. from January 25th until late on January 28th, Dean was in Florida. He stayed at an Allure Suites hotel where he produced a driver's license to identify himself. You're going to learn a little bit about cell phone technology in this trial, including how cell phone records can help establish the location of a particular cell phone based on the cell towers that phone uses to make and receive calls and text messages. What you'll hear is that Dean's cell phone repeatedly used cell towers in and around Cape Coral, Florida, from January 26th through January 28th, including as he was talking to people back in New Hampshire and trying to reach out to Christine, who had stayed behind. On the evening of January 25th, back in New Hampshire, Christine came home with Jenna. In this image, Christine is the woman circled in purple, and Jenna is circled in green. Jenna was not a regular in this group, and many people associated with Dean and Christine, including the defendant, had never met Jenna before. Christine and Jenna got together that evening with a friend named Steve Clough. Steve was friends with Christine and Jenna and was also a drug associate of Dean and Christine's. The three of them had dinner. Christine had something of an antiques refurbishing side business, and Steve helped her bring a grandfather clock in from her car. On the next day, January 26th, Josh Caldwell and the defendant were out in Farmington. They saw Christine's car parked with a woman inside. Thinking the woman was Christine, Josh got into the car to say hello. He discovered that it wasn't Christine. The woman in the car was Jenna. The defendant stayed in his car. He didn't get out, and he didn't meet Jenna. Then the defendant and Josh went back to Josh's house, where the defendant stayed until the early evening. After leaving Josh's at about 10 p.m., the defendant texted Josh to say that he was heading to Dean's house. Not long after that, at about 11 p.m. on the 26th, the defendant arrived at Dean's home, where Christine and Jenna were present. It wasn't unusual for the defendant to be there. In fact, he had lived at 979 Meadowborough Road for some time before that. The defendant stayed at the house for a couple of hours, leaving at about 1 a.m. on January 27th. In this picture, you can see Christine, who's circled in purple, leading the defendant, circled in red, to the door. When the defendant left, he went back to Josh's house. Josh will tell you that when he saw the defendant in the early morning hours of January 27th, 2017, the defendant was acting strange. The defendant seemed paranoid and frantic. Josh had seen the defendant high on crystal meth before, and this was even worse than what Josh had seen in the past. Apparently concerned for the drug organization he was involved in, the defendant asked Josh if Josh thought Jenna might be an informant or someone who provides information to the police. The defendant expressed concern over whether Dean knew Jenna was at the house and what Jenna might be doing there. The defendant asked Josh if Josh thought the defendant should do something about it. In the end, the defendant told Josh he was going to go set up some cameras at Dean's house to see if he could figure out what was going on. And then the defendant left, fueled by his extreme paranoia. At about 2 a.m. on January 27th, the defendant arrived back at 979 Meadowborough Road. You will see during the course of this trial that no one else besides the defendant, Christine, and Jenna appear in any of the surveillance videos after 2 a.m. on that day. Not long after arriving, the defendant began taking scattered steps to hide different areas of the house from view. First, the defendant blocked the view of one of the security cameras in the house. Then, during the 4 a.m. hour, the defendant went back and forth between the house and the detached garage. You'll see that the defendant went back and forth between the house and the garage multiple times. Crime scene investigators would later find that all of the ground level windows in that garage had been covered in green spray paint. They would find in the laundry room of the house 2 used cans of green spray paint, each of them with the defendant's fingerprints on them. According to the surveillance videos, in the early morning hours of January 27th, Christine was wearing what appears to be a cowl neck sweater, lighter colored pants, and has on a noticeable pendant necklace. You'll hear that cell phone records of Christine's phone show that she placed a call to Dean at 1:47 a.m. The two of them spoke for about 15 minutes. That was the last outgoing communication from Christine's phone. Jenna was apparently in and out of bed in the morning of the 27th. She took some selfies from bed between 4 and 5 a.m., and the security cameras showed she was doing laundry at about 6:40 in the morning. The videos show that at that time, Jenna was wearing a darker colored hoodie over a lighter hoodie with some writing on it. The selfies show that lighter hoodie had pink strings on it, and it was over a shirt with a small floral print on it. Jenna would soon be murdered in that exact spot. The last video captured by the 979 Meterborough Road surveillance system on January 27th shows only the defendant. At about 6:57 a.m., the defendant quickly walked to the door and locked it. He was wearing a white trucker-style hat, a flannel shirt, and carrying his shoes in his hand. There are no more videos from the 27th. The defendant walked off camera in the direction of the security system controls, and then the system went dead. The evidence will show that at this point, the only 3 people in that house were the defendant, Christine, and Jenna. At some point after locking that door, the defendant struck. The murders were disorganized and hyper. They weren't cold and calculated. They were emotional and they were passionate. The defendant struck Christine multiple times in the head with a blunt instrument. These were extremely forceful blows, which caused bleeding in her brain. One of the blows was so powerful that it caused extensive fracturing around a large part of Christine's skull. You'll hear that Christine was alive for these blows. The defendant also stabbed Christine 8 times in the neck and chest. He cut the carotid artery in her neck, penetrated both of her lungs, and pierced her heart through and through. You'll hear Christine was alive for at least some of those wounds. Christine tried to defend herself. She suffered broken and cut fingers in an attempt to ward off this vicious attack. But she wasn't successful. The chief medical examiner for the state of New Hampshire would later rule Christine's death a homicide, caused by multiple stab wounds with perforations of the lung and heart and blunt impact injuries of the head, causing complex skull fractures and bleeding and swelling of the brain. The attack on Christine likely took place in the outdoor porch area, as her blood would later be found in that location. The defendant murdered Jenna while she was in bed. There was no evidence that she tried to defend herself. She was likely sleeping or unconscious at the time. As with Christine, the defendant also struck Jenna in the head, causing fractures of the skull and brain bleeding, although not quite as extensive as what he had caused Christine. Jenna was alive for these blows. The defendant then stabbed Jenna to death, inflicting 43 stab wounds to her neck, chest, and back. He sliced her carotid artery and her jugular vein and pierced each of her lungs multiple times. Jenna also suffered multiple fractured ribs. You'll hear she was alive for at least some of those wounds. The chief medical examiner would later rule Jenna's death a homicide caused by multiple stab wounds with perforations of the left carotid artery and lungs. After murdering these women, the evidence will show the defendant tried to clean up the scene. His efforts were as disorganized and hyper as the killings themselves. He hid the bodies by wrapping them in bedding, drop cloths, and a frayed tarp. The tarp left blue strings in Jenna's room and throughout the house. He then discarded the bodies under the porch, piling junk on top of them as if they were trash. You'll see and hear that beneath this bench, wrapped in those tarps and other coverings, investigators discovered the bodies of Christine Sullivan and Jenna Pellegrini. After committing the murders, the defendant returned to Josh Caldwell's house sometime around 11 a.m. or noon on January 27th. When the defendant arrived at Josh's, he grabbed a beer out of his car and went inside. Josh will tell you that when the defendant walked past him to enter the house, he said to Josh, "Interesting night." The defendant was behaving strangely and smelled strongly of body odor. He was wearing only a t-shirt, not the flannel shirt that he had on previously. Continuing with his strange behavior, the defendant asked Josh for a change of pants, which Josh provided and which the defendant then changed into right there on the spot. In addition to the beer he had taken from his car, the defendant began drinking shot after shot of alcohol, about 3 or 4 shots in all. Josh will tell you that the defendant was just staring off into the distance as he was doing this. Concerned that the defendant might have done something more than just set up cameras at Dean's house, Josh told the defendant that Dean would be pissed if the defendant had gone up there and done something stupid. To which the defendant's reply was to ask in a surprised tone, "Really?" Not long after, the defendant left Josh's house. As the defendant left, he told Josh he had to go tie up some loose ends. Sometime after leaving Josh's, you'll see the defendant went to make some purchases. He first went to the Walmart in Rochester, where he purchased a prepaid phone card. Then the defendant went to the Lowe's in Rochester. A significant amount of Christine's blood had frozen on the porch next to a hot tub, and he needed to melt the ice. At Lowe's, the defendant purchased 2 bags of solar salt, 2 containers of Prestone driveway heat ice melter, and a 2-quart bottle of ammonia cleaner. Investigators would later find a blood stain next to the hot tub underneath a purple rug. DNA testing would confirm the blood on that rug was Christine's. The blood stain was covered in what appeared to be ice melter. And just inside the door, investigators found a nearly empty container of pressed stone driveway heat. That container had only the defendant's fingerprints on it, no one else's, including one of his fingerprints on the cap. A second container of pressed stone driveway heat would later be found in the defendant's car, along with an open and partially used bottle of ammonia cleaner. While cleaning up the scene, the defendant also concealed a number of items in a couple of trash bags which he left in the laundry room of the house. In that laundry room, investigators would find a clear plastic trash bag containing a number of blood-stained items. DNA testing would confirm the blood on those items was Christine's. That clear plastic trash bag had the defendant's fingerprints on it. No one else's prints were on that bag. In the black plastic trash bag, also found in the laundry room, investigators would discover multiple blood-stained items, including a sheet that was soaked with what DNA testing would later confirm was Jenna's blood. Many of Jenna's personal belongings were also in this trash bag. This bag had the defendant's fingerprints on it. No one else's prints were on that bag. In a back bedroom on the main floor of the house, investigators found an unmade bed with a large blood stain on the bare mattress. There was a small rug lying next to the mattress. DNA testing would confirm that blood was Jenna's. Investigators would ultimately find the wrapped bodies of the two women in the junk heap outside where the defendant had left them. You'll see that when their bodies were found, both women were wearing the clothes they can be seen wearing in those videos from early in the morning of January 27th. Christine in a cowl neck sweater, light-colored pants, and the pendant necklace, and Jenna in a darker hoodie over a lighter hoodie, which was over a floral-printed tank top. Next to the junk heap, where the defendant hid the women's bodies, there was a bucket with some bloody paper towels and a pail with a white trucker-style hat stained with blood. The evidence will show that this was the hat the defendant was wearing in that final surveillance video from January 27th. DNA testing confirmed that both Christine and the defendant's DNA were on that hat. While the defendant was cleaning up from the murders, Dean was attempting to get in touch with Christine. Between about 10:50 in the morning and 12:12 in the afternoon on the 27th, Dean called and texted Christine's cell phone, but she didn't answer his calls. She didn't respond to his text messages. All of these calls and texts used cell towers in and around Cape Coral, Florida. Another individual named Jason Parker was at the same time trying to get in touch with Christine. She didn't respond to his calls. She didn't answer his text messages. Kathy Bradstreet also tried to get in touch with Christine, to no avail. Later that afternoon, still on the 27th, Josh drove past Dean's house to see if anything was going on. When he did, he saw the defendant's car parked up close to the house, where Christine would usually park. Josh decided that he had to let Dean know something was up, so he reached out to Dean. "How bad is the news?" asked Dean. 10, said Josh. "Oi," replied Dean. Josh told Dean he needed to come back from Florida. Josh knew that if something bad had happened in that house, the police needed to get involved. But Josh didn't want to be the one to call the police, knowing that Dean might have drugs in the house. In response, Dean reached out to the defendant to check the house. But the defendant claimed the house was locked up tight. He also told Dean Christine's car was there and that it was locked too. The next day, on January 28th, Dean asked some other people to check the house for Christine. He still had not heard from her. The first was Jason Parker, who went to the house around noon. Nobody answered the doors when Jason arrived. He went in the garage and he saw the painted windows. He cleared the ice off the porch by the driveway and he went up to the enclosed three-season porch on the main floor. He didn't go into the house itself. Later that same afternoon, the 28th, Kathy Bradstreet was trying to reach the defendant. She was concerned about her friend Christine because they had plans for that weekend, and Christine wasn't answering her. But Kathy wasn't immediately able to get a hold of the defendant because the defendant had gotten a new phone. You'll see records and video from the Sprint store in Dover showing that on January 28th, the defendant and his girlfriend purchased a new phone. Kathy eventually learned of the defendant's new number, and she was able to reach him. When she spoke to him, the defendant told Kathy that he had gotten a new phone because he was tired of his old life. He needed a break, and he threw his old phone away. The defendant told Kathy he had been to Dean's house twice. Once he wasn't able to get in, and one time he got in, got freaked out, and he left. But you'll see that the defendant didn't seem as concerned about Christine as others did. On the afternoon of the 28th, when Dean, Kathy, and others were trying to figure out where Christine was, the defendant was shopping, buying new boots, shoes, and other clothes, first at Red's Shoe Barn and then at Target. Later that afternoon, still looking for Christine, Dean called Steve Clough and asked him to go check the house. Steve went to the house with two other people, Buddy Seymour and Nicole Stedman. Nicole stayed in the car, but Buddy and Steve went to check things out. Steve saw that Christine's car was there, parked behind the house. They checked the garage, and Steve saw the painted windows. They checked around the outside of the house, but at first were unable to get inside. At some point, Steve called Dean, and Dean authorized him to break into the house and check inside. Steve and Buddy went up to that three-season porch, and Buddy used a shovel to pry open the sliding glass door that led from the porch into the kitchen. Investigators would later find one of Buddy's fingerprints on the handle of that shovel. The digging part of that shovel was stained with Christine's blood. After entering the house, Steve and Buddy eventually made their way to the bedroom where Jenna had been staying. They saw that the mattress was bare except for a rug. When they lifted the rug, they saw a large blood stain underneath it. They then left the house, but not before taking some drugs and drug paraphernalia that had been laying out. Based on what he was hearing from back in New Hampshire, Dean had bought a plane ticket home from Florida. At about 8:40, Dean boarded the plane in Florida, headed for the Logan Airport in Boston. While Dean was on his way back from Florida, the defendant was out with some friends. He then called his mother, Suzanne, to come pick him up and asked her to take him to rehab. Suzanne will tell you that the defendant seemed hyper and emotional and that she was frightened for him. She took him to the Wentworth Douglas Hospital emergency room to try to get him some help. While there, she heard the defendant tell hospital staff that he had been using cocaine, meth, and some other drugs. Dean arrived back at the Logan Airport at about 11:38 p.m. on the 28th. He was picked up by Josh Caldwell, who brought Dean back to 979 Meterborough Road. They arrived at about 1 or 1:30 in the morning on the 29th. Josh helped Dean clear the house to make sure no one was inside. Dean and Josh saw the blood stain on the mattress, and then Josh left the house, taking some drugs with him when he left. A little while after that, Steve Clough arrived at the house in case Dean needed anything. Dean turned on the surveillance system, which captured him examining things in his laundry room that were different than when he had left. This clip shows a date and time of January 27th at 9:35 a.m. But what the forensic expert who analyzed the surveillance recorder will tell you is that when he turned on the device to analyze it, its internal clock was off. It was off by 1 day, 17 hours, and 18 minutes. If you add 1 day, 17 hours, and 18 minutes to 9:35 on January 27th, you get approximately 2:53 a.m. on January 29th, which you'll see is consistent with when Dean arrived home and was checking his house. In the clip, Dean is dressed in the same clothes he was wearing when he arrived back at the Logan Airport from Florida and when the police arrived later that night. That bottom image is taken from police body cam footage when they responded to Dean's 911 call. The man circled in orange is Steve Clough, who was still there with Dean when the police arrived. The forensic expert is not going to be able to tell you when the DVR's internal clock went wrong, but you'll see that other recovered videos have date and timestamps consistent with corroborating evidence, such as the defendant telling Josh he was going to Dean's house and the defendant being seen arriving a short time later. Dean called the police at about 3 a.m. on January 29th, 2017. After Dean called 911, the police arrived and began their investigation. They found the wrapped bodies of the women and the other items mentioned earlier. They also found out on the kitchen counter a number of cleaning products, including bleach, all-purpose cleaners, carpet cleaners, and air sanitizers. Police found traces of blue frayed tarp in Jenna's room and throughout the house. And as the police began to investigate, they identified the defendant as someone they wanted to talk to. On January 29th, a state police trooper called the defendant. At the time, the defendant was at his brother Jeff's house in Newton, New Hampshire. The defendant and his girlfriend had taken his girlfriend's car to Jeff's house. The defendant told the trooper he was willing to speak with investigators and gave the trooper his brother's address. But after he got off the phone, he told his brother he was going outside to wait for the police. And then he left in his girlfriend's car, leaving his girlfriend behind. But before driving away, the defendant removed his girlfriend's New Hampshire license plates and replaced them with his brother's roommate's Massachusetts plates. You're going to hear that in the following days, the defendant continued to act like someone who had just committed a life-altering act. Over the course of the state's presentation, you're going to hear from witnesses who used and sold drugs. Their attitudes towards the police are probably a lot different than yours are. It's not necessarily their first instinct to call the police when something suspicious has happened. They likely lied to the police when asked about their own drug use and drug sales. What we want to ask you to consider as you listen to those witnesses is that while witnesses may lie about their own drug use and their own drug sales in an interest of self-preservation, that same interest does not give them a reason to lie about what they knew about the murders of Christine and Jenna. In fact, the majority of the civilian witnesses the state will present to you were friends with Christine, Jenna, and/or the defendant. So we invite you, as we discussed with each of you in jury selection, to keep an open mind when you're listening to these witnesses. Look for how the scientific, video, photograph, cell phone, and other evidence corroborates the testimony of these witnesses. Pay attention to when a witness might have had that self-preservation motive to lie, versus when they were trying to make sure the police had the best information to use in their investigation into the murders of Christine and Jenna. Now, I imagine when I'm done speaking with you in a few minutes, defense is going to come up here and they're going to tell you that somebody else murdered Christine and Jenna. They may talk to you about untested evidence and may ask you to speculate. They're going to create a boogeyman, and they might even give that boogeyman a name. We don't know who that's going to be yet. And it's true that Dean and Christine had a terrible relationship. Dean was abusive, and he didn't hide the way he felt about Christine, often saying and texting horrible things about Christine to others. It was no secret among anyone acquainted with the two how Dean treated Christine. But on January 27th, 2017, Dean was in Florida. On January 28th, when Dean thought something was wrong in New Hampshire, he came back. And when Dean came back, he called the police. We're not going to make any excuses for Dean or the way that he treated Christine. But the evidence will show that when he thought something had happened to Christine, he didn't run. He wanted law enforcement to investigate. They did investigate. And by the end of this trial, you are going to see that the evidence they gathered conclusively shows the following things. When the defendant locked the door to 979 Meadowborough Road at 6:57 a.m. on January 27th, the only three people in that house were the defendant, Christine, and Jenna. Christine and Jenna were killed in the clothes they were wearing during those videos in the early morning hours of January 27th. Christine was savagely beaten in the head and stabbed 8 times. Jenna was beaten in the head and stabbed 43 times. And after he murdered them, the defendant concealed their bodies by wrapping them up and piling junk on top of them like trash. Hours after the murders, the defendant purchased 2 containers of Prestone driveway heat ice melt, which was later found poured over Christine's frozen bloodstain, a near-empty container with the defendant's fingerprints on it, no one else's, found nearby. The second container found in his car. Objects stained with Christine's blood were concealed in a clear plastic trash bag with the defendant's fingerprints on it, no one else's. Jenna's personal belongings and a sheet stained with her blood were concealed in a black plastic trash bag with the defendant's fingerprints on it, no one else's. And then, when the police wanted to talk to the defendant, he swapped out the license plates on his girlfriend's car and he fled. There is no boogeyman. The evidence in this case will show that the defendant is the only one who cleaned up the scene, the only one who fled from the police, and the only one who killed. And at the end of this trial, we'll ask you to return a verdict consistent with that evidence. Guilty. Thank you.
On Friday, January 27th, Christine and Jenna fought back against their killers. They fought so hard that their killer's DNA got embedded under their fingernails. That killer's DNA was not Tim's. DNA testing definitively excluded him. In the struggle, Christine broke her ring finger and the ring she was wearing. The killer's DNA was on that ring. Again, DNA evidence excluded Tim. Christine fought back so hard that she injured her killer, sending his blood onto the ceiling. Again, that DNA was not Tim's. Tim did not kill Christine and Jenna. Tim was not told to kill Christine or Jenna. And Tim did not have any motive, any incentive, or any reason to kill Christine or Jenna. Despite evidence that points away from Tim, despite the lack of physical evidence and the absence of any motive, the state will ask you to convict a man for murders he did not commit. Tim is not guilty. This will be a long case. And at the end, you're going to have a lot of questions. Questions that aren't trivial. Questions that are serious and fundamental, that any person would want answered, especially in a case of this magnitude. Questions about the quality of the evidence. These questions are what reasonable doubt is. And the state won't have the answers to these questions. Among others, they won't and can't answer when were the women killed, how were they killed, how many people were involved, and crucially, why were they killed? Who had the motive to kill them? The state may say at the end that they don't have to answer these questions. But don't let the state dismiss questions that they can't answer as questions that don't matter. The state must answer every question that gives you reasonable doubt. And when they don't, you must acquit Tim. The state's inability to answer these questions starts with the investigation. The police carried out a distracted and incomplete investigation. Their errors were so egregious that we had to stop the first trial more than 2 weeks into evidence. The state may tell you that that's all in the past. And in one important respect, that's true. What's done is done. There's no going back in time to conduct a thorough and focused and proper investigation. There's no transforming an unreliable investigation into a reliable investigation. Now, we're not saying that this was a dishonest investigation, but rather that it was fatally flawed. And it was flawed in a variety of ways. Throughout this case and throughout the evidence, you'll see patterns. The state didn't collect evidence that they should have. The state didn't test scientific evidence they should have. The state ignored leads they shouldn't have. The state trusted self-interested people and dubious sources that they shouldn't have. And based on that, they made choices and decisions about this case that they shouldn't have. The damage of those decisions resonates to this moment. The foundation of the state's case is weak, and most importantly, its orientation toward Tim is misplaced and wrong. It will not withstand your scrutiny. So, what's the broader framework of this case? Well, it starts with drugs. The state told you, each of you last week, that this case involves drug users and drug sellers. In fact, this case sits within a dynamic universe of people buying drugs to use them, people buying drugs to sell them, people selling drugs to buy more drugs, and most importantly, people striving to grow their drug-selling enterprise. Now, Tim himself had bought drugs, he used drugs, and he sold drugs for Dean. But he had no desire for bigger and better things in the drug world. In fact, one source of tension between Tim and other players in this case was his growing detachment from this world. He was seen as lazy and becoming unreliable. And that was a problem for the committed guys. Buyers were getting angry. Revenue streams were becoming threatened. And word about this was getting back to Dean, the boss, who texted Josh, the guy Dean saw as Tim's replacement, that Tim was, quote, being stupid, and that Dean wouldn't let it slide. So how did things get to that point? Well, it starts with Dean and Christine. They'd met a few years back in Florida, and Christine came to New Hampshire to help Dean with his drug operations here. In 2017, Dean also had a home in Cape Coral, Florida, where he spent most of his time running another corner of his drug business. Meanwhile, Christine was up here running the drug business in New Hampshire. She also had a legitimate side business of her own, selling secondhand items she refurbished. Tim had become friends with Dean and Christine, meeting Dean through going to music festivals. Tim would end up selling drugs for them to local people in the area. He would also look after the house when both of them were gone, and he often did errands or chores for Christine. At the time of the murders, he lived in Dover with his girlfriend, and his parents and brother lived nearby. Now, Dean and Christine were romantic partners as much as they were business partners. But by 2016 and 2017, both of those relationships completely deteriorated. Dean saw Christine as a disloyal, lying bitch. His words. Christine was getting in the way and jeopardizing Dean's drug enterprise. He couldn't wait until she was out of the picture, one way or another. 2016 is also the time that Josh Caldwell enters the picture. Now, Tim and Josh were from the same area and knew each other in the early 2000s through a mutual friend. They fell out of touch but reconnected in 2016. And at that time, people owed Dean drug money. People were in debt to him. And Dean wanted his money. He needed somebody to collect his debt for him. And that was a job that everyone knew that Tim did not, could not, and would not do. You'll hear that Tim is gentle and deferential, is not an aggressive guy. Tim introduced Dean and Josh in the fall of 2016. Josh seemed to fit the profile of what Dean was looking for, a go-getter. Now, you're going to hear from Josh. He's going to present to you today as a reformed man.